Welcome aboard, applicants. Let's begin with question 2 of October 2019 first year law students exam are called the baby bar. Okay, so with question 2, we're beginning with call number 1. What contract rights and defenses, if any, do Lewis and Ella have against one another, and who is likely to prevail? Discuss. 2. What contract rights and defenses, if any, do Ella and Sarah have against one another regarding the 7,700 and the 5,500 prices? And who is likely to prevail? Discuss. Okay, right here, we don't even need too much more information. We know our area of law, our contract rights and defenses right here. Highlight this for you. Contract rights and defenses. So we know what area of law we're dealing with. Absolutely, contract law. So we're going to come down here and put our shopping list or checklist. We're going to say formation, F for formation, third party, T. Then we're going to come down and we're going to put possibly P for performance related issues. And then we're going to see D for discharge. And here we're going to say B for breach and R for remedies. Why am I only using one letter? Every minute counts on our essays, and we're taking the time here. I'm taking the time here to explain to you that it is important to have a one-letter capitalized word that represents the issue or set of issues that you're going to be looking for in your fact pattern or in your question. Why is that important? Again, I'm emphasizing this twice. I get that, but it's that important that when we go into our questions with a focus, we'll be able to see more issues than if we hadn't. And I know it sounds kind of funny, but that's exactly where all of the issues, all of our ability to be able to spot the issues comes from. With that focus. Focus comes as a result of our shopping list. We put down our shopping list. We can now go in and spot our issues from our question. Now, let's start. Ella has owned and operated Ella's Garden, a successful landscaping service and nursery, for several years. One day, Lewis called Ella's Garden, wanting to buy some exotic ferns and unusual ornamental trees for his backyard. Ella took the call, checked her price list, and informed Lewis that she would sell him the ferns and trees for $5,000. Lewis excitedly agreed and said he would drive right over in his truck. An hour later, Lewis pulled up to Ella's Garden in his truck. He identified himself to Ella, gave her $1,000 in cash, and told her that he would give her a check for the rest. As Lewis loaded his truck, Ella realized that she had inadvertently referred to an outdated price list when she quoted the $5,000 price to Lewis. The actual price should have been $6,000. Ella told Lewis that she could not sell him the ferns and trees for anything less than $6,000. At that moment, Sarah, another customer, approached Ella. A week earlier, Sarah had hired Ella's Garden to redo Sarah's landscaping, specifically in preparation for the wedding of Sarah's daughter. The comprehensive written contract, which does not mention the wedding, specified a $7,700 price for extensive work, including weeding and trimming, walkway placement, and the purchase and installation of numerous plantings. Subsequently, Sarah's daughter canceled the wedding, and Sarah no longer wants Ella's Garden to do the work. Sarah told Ella that she would go forward with the contract, though if Ella would do the work for significantly less money, that is $5,500, and Ella very reluctantly agreed. Now we need to go back through here and look at our facts or I should say, we should probably start laying out our call before we go in and we issue spot on the second round. Our first contract is between Lewis and Ella. All right, we should probably say Ella v. Lewis here, because Ella is the person suing Lewis. So E for Ella and L for Lewis, our first call. Our second call would be Sarah, or so say Ella v. Sarah. Okay. And we want to make sure to include in our call as well that right here that we're addressing our call the question by saying contract rights and defenses. So what contract rights and defenses does Ella have against Lewis? Does okay? What if any does okay? What contract rights do Lewis and Ella have against one another, and who is likely to prevail? Okay. Now call number 2. Okay, we're going to say, make sure that's right there. Okay, what contract rights and defenses? What contract rights and defenses do Ella and Sarah have against one another? And who is likely to prevail? Okay. Now we can be confident that we have addressed our call. I said regarding the 7,000 700 and the 5,500 prices. Okay, and who's likely to prevail? Okay, now I might sound like I'm going through this a little quickly, but we want to make sure to simulate as close as possible to testing conditions, so that when we practice, we're practicing in our testing environment as close as possible. Okay, so we can get the best benefit out of this as possible. Now, up here, we're going to take a look at the first. We're going to take a look at our facts again. Okay, now Ella has owned and operated Ella's Garden, a successful landscaping service and nursery for several years. One day, Ella. Okay, first, we're going to come down here. We're going to throw down our applicable law. Okay. Now, we want to make sure what Ella and Lewis's contract pertained to. What was their contract concerning? It's okay. So Ella has owned and operated Ella's Garden, a successful landscaping service and nursery for several years. One day, Lewis called Ella's Garden, wanting to buy some exotic ferns and unusual ornamental trees for his backyard. Ella took the call, checked her price list, and informed Lewis that she would sell him the ferns and trees for $5,000. Lewis excitedly agreed and said he would drive right over in his truck. Now, at this point, what was the contract between Ella and Lewis for? Those ornamental ferns. So right here was saying that the Uniform Commercial Code, UCC, governs the sale and transaction in goods. Goods are movable, tangible. Let's see, tangible personal property at the time of contract formation. Okay, here the agreement between E and L was for, well, we got to come up here and grab it right here. Ornamental, exotic, okay, some exotic ferns and some unusual ornamental trees. Highlight that. Exotic ferns and unusual ornamental trees. Here we go. Was for the sale of goods because exotic ferns and unusual ornamental trees are movable personal property at the time of contract formation. Thus, the uniform UCC would govern this contract. Okay. Now come down, contract formation. A validly, or an enforceable contract contains, you don't want to forget something, merchants. Excellent. Excellent for spotting that, applicants. Very good job. Merchants are those that regularly deal in the kind of good involved in the contract, or who hold themselves out as having special skill or knowledge of said goods. Here, Ella, E, was it? Now we get to bring in these facts up here. Has owned and operated Ella's Garden, a successful landscaping service and nursery for several years. Ella's Garden, a successful landscaping business. Hence, it is safe to say that E is a merchant of what? Ornamental trees and unusual, let's see, unusual, let's see here. Oh, okay. Exotic ferns, excuse me, is a merchant of exotic ferns and unusual ornamental trees. Okay. However, the facts do not indicate that Lewis was a merchant thus the court will likely find that E is a merchant and L is a non-merchant. Okay, perfect. Contract formation. An enforceable contract contains validly, let's see, valid offer, acceptance, consideration without applicable defenses to contract formation. Without applicable defenses, period. Here, offer. Now, has there been any preliminary negotiations? Let's take a look here. Well, Ella took the call, checked her price list, informed Lewis that she would sell him the ferns and trees for $5,000. Lewis excitedly agreed and said he would drive right over in his truck. Now, one day, Lewis called Ella's garden, wanting to buy some exotic ferns and unusual ornamental trees for his backyard. Okay, so could it be said that Lewis's call was an inquiry? We could say that. We might be able to say that. We'll throw in a quick little discussion. So here, make sure. Okay, here Ella may argue that Lewis's call was a mere inquiry and did not represent a valid offer. Now, this is the point. We could throw this in underneath our offer discussion or talk about this above here. We would say something along this line. Preliminary negotiations are not generally offers, but mere inquiries to make an offer. Here, Ella may argue that Lewis's call was a mere inquiry and did not represent, excuse me, a mere call. Lewis's call concerning, let's plug in some facts here. He says he called Ella's garden wanting to buy some exotic ferns or unusual ornamental trees. Right here. Wanting to buy the exotic ferns and unusual ornamental trees. Okay, was a mere inquiry and did not represent a valid offer. Thus, the court will likely find that L's call to Ella's garden was a mere inquiry and not an offer. Okay. Now down here under offer, we want to make sure to talk about offer. Offer is a present manifestation of intent to be bound, containing certain and definite terms for his own backyard. Okay, excellent. We'll throw that in there. Ornamental trees for his own backyard. Excellent. Very, very good, applicants. Now, offer is a present manifestation of intent to be bound, containing certain and definite terms, communicated to an... Oh, he is not a merchant. Right, he is not a merchant. Exactly correct up here. That Lewis is a non-merchant, not a merchant. Exactly right. Or you know what? I like how you put that. We'll do that. Is not a merchant. Okay, very good. Communicated to an offeree. He would believe that her was an offer Absolutely. That's what we're going to be talking about here under offer. Exactly right. Because offer is a present manifestation of intent to be bound, containing certain indefinite terms communicated to an identified offeree. The quote. Yes. Here, remember though, an intent to be bound is measured by a reasonable person. In the her quote was an offer. Exactly. Here, the court will likely find that ease. We'll use your observation. Wonderful observation. Ella's quoted price to L was a representation of her intent to be bound. Now, remember down here is would a person, a reasonable person in Lewis's position, consider that Ella's quoted price being her. Yeah, yes, exactly right. That's exactly right. So Ella took the call. Checked her price list, and informed Lewis that she would sell him the ferns and trees for $5,000. So let's come down here and take a look at this. Here, the court will likely find that Ella's taking L's call, checking the price list, and quoting quoting the $5,000 price. Let me quoting the $5,000 price was a reasonable representation of her intent to be bound. Further, the terms appear certain and definite because what? They include quantity, which is what? The up here, I guess we'll take a look. Exotic ferns and unusual trees. So, timing is everything on this essay. Exactly right. Exactly. So we're trying to get everything done in as efficient time as possible. Exactly. Now, he took the call, checked her price list, and informed Lewis that she would sell him the ferns and trees for $5,000. So we come down here and we'd say quantity agreed to by E and L. We want to make sure to throw in the price here. $5,000. Parties E and L. Time for performance. Oh, no, I mean when she told Lewis that she had quoted him the wrong price. Right, that's exactly right. That's it. See that right at that moment, she would be in a sense be making the mistake. She's claiming that she made a mistake. She's claiming that her defense is that she mistook the price and she quoted him a wrong price, and therefore the price should actually be 6,000 rather than 5,000. That's exactly right. But we'll want to make sure to raise those particular arguments under the issue that it goes with. Excellent. Now, time for performance, reasonable time, and subject matter. Ferns and trees. Excellent. Okay. How do you talk about her offer being not an offer? Okay, well, see, remember though, right up here, we want to make sure that I think what we're talking about is when she took the call, checked her price list, informed Lewis that she would sell him the ferns and trees for 5,000. Now remember, is that the offer? And that's what we got to ask ourselves here. Or do we say that Lewis excitedly agreed and said he would drive right over? That is that acceptance or is that an offer? And that's what I'm asking you. What do you think? That is my exactly. I see that Ella's taking the call, checking her price list, and informing Lewis that she would sell him the ferns and trees for 5,000. That's the offer. And what Lewis is doing, Lewis is accepting the offer by excitedly agreeing to it and saying that he would drive right over in his truck. That's the acceptance. And that would be in essence the meeting of the minds as well. That's why when we come down here, oh, do I simply state both sides of the issue? Right. That's exactly right. Here, E has okay. Well, let me come down here to offer. Here, the court will likely find that Ella is taking Lewis's call, checking the price list, and quoting the $5,000 price. Oh, I said quoting the $5,000 price was a reasonable representation of her intent to be bound. Now remember, are you saying at this point bring up the $6,000? Because see, I don't see that's applicable here because that discussion would be taken up under the defense of mistake, most likely unilateral mistake, because Lewis may or may not have known. Had he known and taken advantage of that, then we have mutual mistake, and that may be a valid defense for Ella to possibly, pardon me about the. Okay, yeah, don't I say Lewis's side of the issue, right? And that would be under the defense of mistake, right? Rather than under offer, because we need to find an offer here. We could say, okay, the court would like to find that. Okay, like to find that what? Oh no, no. Okay, what are you saying? While you're chiming in, I'll okay. Lewis will say that he thought Ella had made an offer. Okay, right. Okay, so okay, I get what you're saying here. Here, L will argue that E made an offer because she took his call, checked her price list, and quoted him the $5,000 price. Is that it? But Ella will say that she was just giving a price over the phone. That's exactly right. And there is your statute of frauds argument right there. That's exactly right. Also, L will argue that a reasonable person in his position would understand that Ella was quoting him an offer, or making him an offer, I should say, excuse me. For the trees and ferns. Okay. Okay, I see what I need to say. Okay. Thank you so much for that question. Very well done. So we will say here that here L will argue that E made an offer because she took his call, checked her price list, and quoted him the $5,000 price. Also, L will argue that a reasonable person in his position would understand that E was making him an offer for the trees and ferns. Further, the terms appear certain and definite because they include quantity, the quantity agreed to by E and L. Oh, because there are so many facts about the telephone call. Oh, yeah, you need to put those facts in your paper. Exactly right. Exactly. And that's why we're getting to that right after offer here. Therefore, or should this after right after we form the contract, we're going to talk about whether or not there are defenses against enforceability. Thus, right here, excellent. Okay, so thus the court will likely find that E made an offer to L. Okay, excellent. Now acceptance. Remember, acceptance in the Uniform Commercial Code would be mutual assent. Now here, or I should say acceptance is over the phone, exactly. Acceptance is a what? Unequivocal assent to the terms of the offer. Here, Lewis will argue that he agreed to Ella's offer by what? Let's see, back up here. Oh, I want to make, okay, back up here. Excitedly agreeing and saying that he would drive right over in his truck. Oh, let me bring this over here. There we go. Here, L will argue that he agreed to Ella's offer by excitedly agreeing to the terms. Oh, how do I put the terms of the offer in offer? Okay. Well, you could do it like we did it here, where we put it in a paragraph format, kind of like this, or you could stack them, kind of like something like this. We'll take a look at this. Quantity, price, parties, time for performance, and subject matter. And then fill those in with the specifics from your fact pattern, and then conclude as to whether or not there was or was not an offer. So that's something to, two different ways of basically accomplishing the same task, which is dealing with the legal terms, quantity, price, parties, subject, time for performance, and subject matter within our concerning our specifics from the facts, and then concluding. You can do that, or you can stack the issues here. So whether it's what you're more comfortable with, I would probably say, okay, I see the intent to be bound being satisfied. Yes, exactly. The intent to be bound was satisfied. Right. And that's why you might ask, do I say that the intent to be bound was satisfied and then move on to terms? You can do that. Like, for instance, if we broke this up just like this. Thus, well, yeah. However, how the presentation of terms is a bit cloudy. Oh, okay. That's why we tend to talk about intent and terms together, and whether or not this and the communication. Because we were saying here that And that's what I needed to bring in more, is that there was, yeah, there was a communication. So let's walk through this together. Okay, so here L will argue that E made an offer because she took his call, checked her price list, and quoted him the $5,000 price. Also, L will argue that a reasonable person in his position would understand that E was making him an offer for the trees and ferns over the phone, like you pointed out. Hence, E was, or E made L an offer and communicated this offer to him over the phone. Now, you might ask yourself, would I take the time now and break this paragraph up, or combine it into one paragraph? At this point in the juncture, I probably would just combine it in the same paragraph, and then, because it tends to go better together than it does separately. Now, remember, there are situations that would necessitate additional paragraphs, but I don't see that this is one of those. Further, the terms appear certain and definite because they include quantity, the quantity they agreed to by E and L, which is not specified, but it's what they agreed to in terms of quantity. Yeah. Price, $5,000. The parties, E and L. Time for performance, reasonable time. And subject matter, ferns and trees. Now, coming down, see, that's why at this point, too, this is just another way of doing the exact same thing. And then saying that, thus, the court will likely find that Ella made an offer to Lewis. And that's what we need to find here, is that there has been an offer made. So this is where one would put the terms. Yes, right here would be, if you're going to put the terms like up here, some people put quantity, they'll put the facts here. You could use that. One option is putting the facts by themselves and putting this in quotations, or in parentheses, and are, yeah, stack them. You could stack them. Yeah. So yes, I agree too. If I could, of the three, if I was to recommend one, I would stack my issues because it's more visible. Somebody who's reading, your readers are more likely to see your terms, the offer terms, the certain and definite terms that you're trying to establish, a little easier and a little clearer. And so that's, yeah. If my recommendation is to stack them, exactly. Very good point. So then, if we were to do that, let's do the quantity term right now. We'll say the quantity agreed to by E and L. Price term, obviously we already know that. It's a $5,000 price. Parties, E and L. Time for performance. Because there really isn't necessarily a time for performance indicated, we could say reasonable time. And subject matter, trees, or ferns and trees. Oh, he said 1 hour. Okay. It'll be, let's see, let me double check. Here, let's see. One day, Lewis called Ella wanting to buy some exotic ferns and trees for his backyard. Ella took the call, checked her price list, informed Lewis that she would sell him the ferns and trees for $5,000. Lewis excitedly agreed and said he would be right over in his truck. An hour later, yeah, I get where you're seeing the hour. Yeah, being coming right over in his truck, that could be considered an hour. An hour later could be considered within reasonable time limits. So I see that. Absolutely, we could say reasonable time, comma, 1 hour later, something along that line. And then ferns and trees for subject matter. And then thus the court will likely find that Ella made an offer to Lewis. Now, under acceptance, switching gears, are right over. Right. 1 hour later, or right over. Yeah, that's, you could point that out. Now, remember, though, we're within that 60-minute time period. We want to make sure that we're tackling everything in as efficient as we can, bring in as much as we can, and that's why I'm so happy we're bringing all these facts in, because that's going to show our readers that we are assimilating our material into our paper. We're applying it. We're doing our analysis. Exactly. Very good job. Now, down here under acceptance, mutual assent. Acceptance is an unequivocal assent to the terms of the offer. Here, Lewis will argue that he agreed to Ella's offer by what? Excitingly agreeing to the terms, and what did he say? I think we already pointed this out, but we'll point it out again. That he would drive right over in his truck. Right here. And saying that he would drive right over in his truck. Okay. Did she agree when she accepted the money? Well, that is an excellent point. Did you could say, well, see, that would make the thing about that though yeah, see, she allowed him to load up the plants, and see, that would be him making the offer. Did Lewis make the offer, or did Ella make the offer? And that's the sticky point on this one. Was it Ella who took the call, checked her price list, and then quoted him the $5,000 that was making an offer, or was it? That is my, yeah, exactly. The question is, see, I see it as Ella making the offer to Lewis, and Lewis accepting it by saying, "I agree. I'm gonna drive right over in my truck." That would be the mutual assent aspect, and that's why I see here that the acceptance. See, what I I just see that in here that it's Lewis who's accepting Ella's offer, not Ella accepting Lewis's offer. Okay, so with that, say thus does it enter my paper when I do not argue both sides. That's what I'm saying. Is there another side on this, on the acceptance? That's what I'm asking myself here. Or is this one of those situations where it's just a slam dunk argument? Here, Lewis, is there anything that Ella would say about him accepting the terms and him driving right over? And that's what I'm putting forward here. Let me come back up to the facts. Let's take a look. Lewis pulled up to Ella's garden in his truck. He identified himself to Ella. Ella gave her the $1,000 in cash. See, that's it. That's it. Does it matter who makes the offer? Absolutely, it matters. It matters because that person then is the master of the offer. The master of the offer can set the method, mode, or means by which the offer can be accepted. Now, let's come down here, and I want to put some more facts in here about Lewis's acceptance. Now, Lewis will argue that he agreed to Ella's offer by agreeing to by accepting the terms, and saying that he would drive right over in his truck. In addition, Lewis will indicate that he accepted the offer by what? By paying the $1,000 at the moment. Okay, right up here. An hour later, pulling up to Ella's garden in his truck, identified himself to Ella and giving her the $1,000 in cash, and telling her that he would give her the rest, give her a check for the rest. Thank you. Okay, now down here, in addition, let's see, accept. Okay, in addition, Lewis will indicate that he accepted the offer by driving over to Ella's garden identifying himself to Ella and, telling, would you ever say something like she did not say we need to fill out a form? I don't see that here as being relevant to our facts because I don't see where that would apply. Is there a situation that you're seeing that I'm not? Okay, so identified himself to Ella and telling her. Let me say. Oh, do you ever add a human side to your argument? Yes. Yeah, that's what. Yeah, that's exactly what we're really trying to get at here. Is there is a human side that Lewis is going to argue that he agreed to Ella's offer by accepting the terms or a solution, so to speak. Probably more. You know what? You could probably bring the two together: the human side to your argument and thus the solution, the resolution can have a human touch to it that you're trying to bring to your reader so that you're showing them that you are indeed, like we talked about, assimilating the material, and we're using the material in terms of what the legal terminology. The elements of our rule statement are coming together with the facts of our fact pattern and making what application. That's exactly what we're after here. Okay, now in addition, Elle will indicate that she accepted the offer by driving over to Ella's garden, identifying. Okay, he accepted the offer by driving over to Ella's garden, identified himself to Ella, paying her the $1,000 and telling her. Let me make sure I got this here. Said he okay, and that telling her or told her that he would give her the rest in a check for the rest. Now, same selected have a solution in them. Did he give her the check right then? Oh, excellent point. That would be the we're looking at this here is telling her that he would give her the rest in a check. Think, okay, well let's put ourselves in Ella's position here. Okay, would Ella allow Lewis to drive off with $5,000 worth of ornamental tree or of exotic ferns and unusually ornamental trees? Absolutely not. So what he's essentially doing is, in essence, giving her $1,000, paying $1,000, and giving her a check for the rest. For the rest of what? The rest of the of the remaining 5,000, which would be 4,000. And so that, okay, right here. Okay, so in addition, Elle will indicate that he accepted the offer by driving over to Ella's garden, identified himself to Ella, paying her the $1,000, and telling her that he would give her the rest in a check. Now, remember here, we don't want to. There are some facts that specifically go to particular issues. The fact that he was loading the exotic ferns and unusually ornamental or the ornamental trees in his truck goes to an exception that we'll be talking about here later on in the statute of frauds. Now, so we can thus say at this point, say, okay, in addition, L will indicate he accepted the offer. So, thus, the court will likely find that Lewis accepted E's offer. Now, do we have any additional arguments here? I don't see any additional arguments under acceptance. So let's roll right into consideration. Consideration is a bargained for exchange of legal detriment. Here, there appears to be sufficient consideration because Ella is exchanging ferns and trees for L's $5,000, and L is exchanging the $5,000 for ferns and trees. Thus, sufficient consideration. Now we're going to be getting into the defenses argument that we were talking about. Right, exactly. That good point. She wouldn't let him take the trees and ferns without paying for them. So exactly, that's what we're saying here. We might, you know what? Let's throw that in there. Ella would not. Oh, Lewis understood that Ella would not let him take the trees and ferns without paying for them first. Okay. Them first, and right when Lewis loaded them into his truck. Yeah, that excellent argument. Right when he right when he was at first, I should say this, comma, right when he was loading them into his truck, or before even. Okay, before loading them into his truck. Okay, good. Okay, thus sufficient consideration. Now down here we want to make sure to throw in the defense statute of frauds. Why? What type of statute or what type of contract are we dealing with here? Are we dealing with a sale of a goods $500 or more? Absolutely. Okay. Statute of frauds requires a writing and a signature of the party to be charged when the contract. Oh, when does irrevocable offer come in? That would be up under offer, whether, or I should say this, under acceptance. We could say that under acceptance as well. Was there an irrevocable offer situation here? As we ask ourselves. Okay, I think we could. Absolutely. How do I do that? Exactly. Irrevocable offer. Merchants. Firm offer. Okay. Now, remember, under an irrevocable offer situation, very good point. Thank you for pointing that out to me. Under irrevocable offer, the merchant's firm offer is saying that when a merchant makes an offer, merchant is merchant is making the offer let's see here. I'm trying to. Okay, okay, all right. Let me put this down here. A merchant's firm offer requires a merchant to make an offer in writing for a stated period of time not to exceed 3 months. Is this where it is important that Ella is a merchant? That's exactly right. Here, E is a merchant and has effectively communicated an offer to L. I should say this, made an offer for to be held open for a stated period of time not to exceed 3 months. Now, but does it have to be in writing? That's exactly right. That's where I'm going here. That's why, see, the merchant's firm offer requirement may or may not be established here, and it's a great point. But I think we can say, oh, this is a great point. I need to check on this really fast. I'm gonna pull up I'm gonna Google this one really quickly. Does the merchant's firm offer rule require a writing? An exception is the merchant's firm offer rule set out in Uniform Commercial Code, which states that an offer is firm and irrevocable if it is an offer to buy or sell goods made by a merchant and is writing signed by the offeror. So yes, it needs to be in a writing. A merchant's firm offer requires a merchant to make an offer in writing. The offer is held open for a stated period of time not to exceed 3 months. So since we don't technically have a writing here, I don't see that this would apply. But I'm going to say that we probably don't even need irrevocable offer considerations. But I'm glad we tackled that. Would we be able to get around the writing somehow? See, that's exactly right. That would be the writing requirement for the statute of frauds. See, that's what we're talking about. I don't see that there's an I haven't come across an exception of merchant's firm offer. Oh, in SOF, that's exactly right. So I'm gonna do here is put a bookmark here. This is a great spot. We considered it and ruled it out. Okay, now down here, the statute of frauds. Statute of frauds requires a writing and a signature of the party to be charged. Here, what we have here is here Ella communicated to L over the phone an offer to, or communicate over the phone an agreement concerning the trees and ferns. Now, this is the aspect here. There does not appear to be either a writing between E and L, and there does not appear to be a signature from L. So thus you would say, thus absent an exception, Ella would be able to bar enforcement of the agreement through what? The statute of frauds. Right here. Okay. Okay. Now, there is an exception, though. Okay, but would not the acceptance of money by Ella satisfy the statute of frauds? See, that's exactly what we're talking about here. The acceptance, the goods accepted and paid for. That's right. As payment for goods received. It's exactly. That's right. Exactly. Here, the statute of frauds has an exception through goods accepted and paid for because what? Lewis. What? Okay, could this also work for merchants from offer? I don't think so. I don't think that this would work because it only works for the statute of frauds sale of goods $500 or more. It's the exception to the statute of frauds. I don't think this is an exception to the merchants from offer. Yeah, exactly. Here, the statute of frauds has an exception through goods accepted and paid for, because L accepted the goods by loading them. Oh, it works for yeah, by loading them. Yeah, because L accept the goods by loading them into his truck, and he paid for them by paying Ella the contract price of $5,000. Now, and we might want to even say that in this here we could say $1,000 right away and $4,000 in a check. Okay. Thank you for being so. Oh, no problem at all. Not a problem at all. Now, here the statute of frauds has an exception through goods accepted and paid for because L accepted the goods by loading them into his truck, and he paid for them by E and by paying E the contract price of $5,000. Okay, yeah, exactly. Okay. Thus, L may effectively argue that there is an exception to the statute of frauds defense. Okay, here now this is where we get to the additional defense here of what? The additional defense of mistake, and this is where it gets really interesting. Okay, mistake can either be unilateral or bilateral. Okay, and okay, mistake as a defense can either be unilateral or bilateral. Now here Ella will argue that she made a mistake concerning the contract price, the quoted contract price. of $5,000 by claiming that she should have given Lewis the actual, this one up here, where's the facts? Okay, right here. That she should have given him the actual price of $6,000. Yeah, or should they, we'll say here that Lewis or Ella realized that she had inadvertently referred to an outdated price list when she quoted the $5,000 price to Lewis. The actual price should have been $6,000. Then Ella told Lewis that could not sell him the ferns and trees for anything less than $6,000. Okay, right here. So she realized. Okay, so let's take a look here. She realized that she had inadvertently referred to an outdated price list when she quoted the $5,000 to Lewis. The actual price should have been $6,000. So let's grab that fact and come down here and use it. Okay. Here Ella will argue that she made a mistake by inadvertently quoting L the incorrect price. Specifically, E will argue that the quoted contract price of $5,000 was outdated and should have been the actual price of $6,000. However, L will counter argue that let's see here, when he took the call, he accepted Ella's offer of $5,000, which may have been a excuse me, a benefit to L if what would, yeah, about her mistake. That's right. However, L will counter argue that he accepted Ella's offer of $5,000. You could say something about it. We could say that we're going to save the however here. That's exactly very good point here. Very good point. Ella will counter argue that he accepted Ella's offer of $5,000. Ella, however, Ella will argue in rebuttal that if it can be established that L was aware of the outdated price list and took advantage of this information, then the contract could be avoided due to mutual mistake, which is which let's see what's here. Both parties were mistaken. See, that's the thing here. I just don't see that took advantage of the information. The contract could be. This is where do you put the fact that he was excited? Right. That's exactly right. Okay. However, Ella will argue in rebuttal that if it can be established that Lewis's excitement about the price, the quoted price, was a result of his awareness of the outdated price list and took advantage of this information, then the contract. See, this is where I'm kind of at a very interesting juncture. Do we say then at this point, exactly what about no meeting of the minds? Then what is it that Ella is going to argue here? Let's take a step back here and look at this. However, Ella will argue in rebuttal that if it can be established that Lewis's excitement about the quoted price was a result of his awareness of the outdated price list and took advantage of this information, then the contract was what? This is what about her taking the money? That's exactly right. We'll bring that. That is a very good point. We'll throw that in here as a closing argument as well. Okay, so here E will argue that she should have made that she made a mistake by inadvertently quoting L the incorrect price. Specifically, E will argue that the quoted price, a contract price of $5,000, was outdated and should have been the actual price of $6,000. L will counter argue that he accepted E's offer of $5,000. E will argue in rebuttal that if it can be established right here that L's excitement about the quoted price was a result of his awareness of the outquoted or outdated price list and took advantage of this information, then the contract could I'm not see that is at this point that is it a mutual would it be a mutual or bilateral mistake? Then the contract can be avoided through mutual mistake of the parties. Basically, we'll throw in no meeting of the minds. Yeah, this a question about the forming of a contract. See there, that's exactly what the defense is trying to undo, is the forming of the contract. So this is a real interesting defense here. I'm going to have to definitely think about this one. So what do you think about this one? Would you put this in the formation stage, or would you keep this argument underneath the mistake, the defense of mistake? Not so much about the breach of the contract. Right. It's not so much about the breach as it is more about the formation of the contract. Right. Can Ellis say here though that okay, that exactly formation. That's exactly right. So you throw it you would put this underneath formation. Now, in what way would you put this under formation? Like acceptance? Offer and acceptance. Okay. Oh, you talk about the mutual assent? Oh, you know what? I'll have to think about that. Yeah. Okay. I'll think about that. That's an excellent observation. Okay. Well, where it is right here, we'll just leave it right here for the time being, and we'll definitely we might pick this up at a later time, in terms of this of the mistake as a defense. Now, however, though, let us move on. Yes, exactly. However, Lewis will argue that if Ella was what was it that Ella was her exactly hooray exactly. However, Lewis will argue that if Ella was uncertain then she should not have accepted his payment of $5,000, which she did. Thus, L will effectively, or is this E defense? Yeah, E's defense of mistake appears weak and ineffective. Okay, now down under after we have our Ella's defense of mistake talked about, we want to make sure to talk about the effect. What about Lewis? That's right here. However, he will argue that if Ella was uncertain about the price, about the quoted price, then she should not have accepted his payment of $5,000, which she did. And therefore, what? That hence there was a meeting of the minds. Sufficient for mutual assent. Thus, Ella's defense of mistake appears weak and ineffective. Now, down here underneath the defense of mistake, I want to point out, okay, would I put Lewis's in the conclude? Yes. Well, you could argue, you could make a quick reference or summary of what Lewis argued in this area in your conclusion. Yeah, you would. Now, the area here involving the area of our facts involving Ella telling Lewis that she could not sell him the ferns for less than $6,000. Does that sound a whole lot like anticipatory repudiation? Because the talks about both of them exactly, and that's why we're referencing that here. We're referencing that they share a very. Are you saying that Lewis would bring up a different issue rather than mistake? And what would that issue be? Okay, okay, yeah. We have to make sure to argue both sides. Absolutely. Well, now, okay, we want to make sure to talk about anticipatory repudiation here. Oh, irrevocable offer. We talked about that. Up here under irrevocable offer, what would make the offer irrevocable? We talked to, okay, first of all, if we're dealing with a merchant, it's merchants from offer. We talked about that, ruled that one out. There's what? Maybe a mailbox rule situation, possibly. Unilateral contract once a performance has begun. That probably wouldn't apply here. Goods accepted and paid for. Does that supply does that suffice for an irrevocable offer? Maybe under detrimental reliance, but see, goods accepted and paid for is technically an exception to the statute of frauds, $500 or more. And so that's why we brought that up here rather than underneath the irrevocable offer discussion. Now let's conclude or talk about our anticipatory repudiation. And then we're going to talk about breach of contract through what? Perfect tender rule. And then we'll talk about remedies. Now, under anticipatory repudiation, what fact here? And I'm just going to because the time is getting. Oh, I do not see anticipatory repudiation. Okay, we should probably come up here and take a look at this up here. Where, when she said she told Lewis that she could not sell him the ferns for anything less than 6,000. Yes, he had that only formation issues. Okay, so we're saying then that there hasn't even been a. Okay, what is it? What is it then? There's no breach issue at this point. I mean, that's what I'm asking is, do you see there actually is a breach of contract issue here? And that's why I want to point this out to you. She told Lewis that she could not sell him the ferns and trees for anything less than 6,000. Okay, yeah. So I'm gonna streamline this a little bit, and so that we can finish out within time here. And so right down here underneath anticipatory repudiation, there's I will possibly say anticipatory repudiation through her statement to Lewis. There's a breach of contract possibly through the perfect tender rule, in that there. Oh, look, in that. Okay, can there be only can only there be if there is a contract? Can there only be AR if there is a contract? Yes. Yeah. You can have anticipatory repudiation in a contract, but remember, yeah, anticipatory repudiation is most likely here we're dealing with a contract. So yeah, I would probably rule out anticipatory repudiation. I see where you're coming from. We'll take that out of there. Breach of contract, perfect tender rule. Did Ella perfectly tender? Well, she allowed Lewis to pay $5,000. Lewis loaded the ornamental or the exotic ferns and unusually ornamental trees, but the situation was such that yeah. But I see a valid exactly. That's why that in a valid contract is how we find breach of contract. We have to have a valid contract in the first place in order for us to breach that contract. And that's why in this situation under remedies, we might be looking at that Lewis can enforce exactly. That's exactly right. And so that's a great point. And I think we'll have to conclude on that next time. We'll take up the rest of this paper on the probably second half of this podcast. And so I appreciate you for tuning in. This is definitely a very interesting question concerning contract law. Lots of great questions that are coming out, a lot of great solutions, and a lot of great learning is happening. I thank you so much for logging in, and best of luck on the bar exam.